Yes.
Thank you, my lords and my ladies. I think before we, just as a matter of housekeeping, an issue arose in respect of the SRA Code of Conduct and regulatory matters earlier. It's something that I've looked at over the luncheon period, particularly in respect of the case of Earlham that my lady referred to. I have forwarded on an email, my learned friend being copied in, to your learned clerk, containing links to the SRA Code of Conduct in the past couple of minutes, and I can only apologise. It was only when I had a look over the luncheon period that, and was able to come back into the courtroom this time, I was able to get the correct email address. So it refers to 2 codes of conduct and 2 pieces of legislation. I am aware that these need to be printed out for access. So I was trying to cut down the specific references to which I will rely.
I think they're being sent to us now by email, and for my lord, they're being printed out outside, and so you'll have them in just a few minutes.
I'm grateful. I'm grateful.
So if you carry on as you would want to, and then we'll get to them when we have them.
The bottom line is, was Judge Gosnell right in Earlham?
The bottom line, as per my interpretation, was that counsel confirmed to him that there were no applicable regulations. I read that differently.
Right. Right. Okay. Well, let's look at it then together when we get the papers.
Okay. So the next case that I was referring to is the case of Goffin Chivers. It's 85 of the bundle, 86 of the electronic authorities bundle. And this is a Court of Appeal case. Aldous J, LJ rather. And the case concerns the situation when a beneficiary enters into a relationship with a solicitor as being a beneficiary, rather than there being, and I expect my lord may raise the issue that the idea of a CFA or a retainer isn't necessarily present in such a case. But if I could take you through that judgment and to page 94 of the bundle, which is 95 of the electronic bundle. And this is Aldous LJ. And if we go to the 5th paragraph, we can see there a reference to a previous, the 3rd paragraph firstly, having concluded that the statement of law relied upon by the judge was obiter, I believe the court should construe 74, the payment in my view should be construed as covering the transfer of money in satisfaction of a bill with the knowledge and consent of the payer. Go on to say that was the view of Stamp J, and then moving on to not the next paragraph but the next paragraph down. In my judgment, both these submissions are well founded. It's clear that if a solicitor without the knowledge or approbation of his client pays his own bills out of monies of his client and hands over the proceeds, that is not payment within the meaning of section 69 of the Solicitors Act. This was said by Rowley J in Reed Jackson. And the reference there to Reed Jackson, which is the next case in the bundle, but this is as far as I go in the reference to Reed Jackson. Payments an operation in which 2 parties take part. If a man collects a debt due to his debtor, and purports to pay his own debt in that way, it's not really a payment unless the other party knows what's being done and agrees that the sum received in that way by his creditor shall be used in the payment of his debt. And again, yes, this is not a situation where there is a retainer or an agreement as there was in Menzies' case, but what is distinguishable there is the importance of the knowledge of the individual and the knowledge that the payment is going to be extinguished in respect of a certain sum. Going over the page, 95 of the bundle, 96 of the e-bundle, page 10, Simon Brown LJ, the final paragraph of that. I just make reference to this point here because it does refer to ignorance. So, on the view of the matter which I take, a beneficiary could, I acknowledge, lose his statutory rights taxation as a result of remaining in total ignorance of the fact of payment for over a year. He would remain entitled to sue for an account. As my lord has explained, moreover, with such an action, by the process of moderation, a taxing master could be directed to inquire into the bill in such detail as was thought appropriate. If the solicitor misconducted himself, perhaps by failing to notify the beneficiary of the payment of his bill and the right to seek taxation of it within a year, then no doubt the court would in certain circumstances think it appropriate to direct the taxing master to inquire very fully indeed.
Can we just go back a little bit? In the second paragraph of Lord Justice Simon Brown's judgment, he said the judge below found on the ground that the beneficiary, here the plaintiff, must A, know and B, agree to the payment. And then he says the authority said to support this rather surprising conclusion is Refish. And then he says Refish decided no such principle. And that I think explains why he says that a beneficiary could lose his statutory right to taxation as a result of remaining total ignorance of the fact of payment.
Yes, but the reference to the total ignorance is the reference to a client burying their head in the sand.
No, it's not being told. Burying your head in the sand is you're told. You're not in ignorance. You just don't act on it. This is not being told. That's what ignorance is referring to.
Yes, but
what's being rejected is that the plaintiff must know and agree.
But the conclusion in this was exactly the same in respect of this engagement process.
But the issue here is about whether it's the beneficiary who has to know as opposed to the trustees. So it's something different.
I appreciate that, but what it does show is the need to be informed.
Well, I mean, it depends whether you've agreed that you need to be informed or not. I mean, if I agree with you that I will pay you, my solicitor, such sums as you may bill me on a statutory bill, if you hold monies on account, what is wrong with that agreement?
Because that agreement refers, well, such sums on account, it could be anything.
No, so if I, not pay monies on account, I will pay you such sums as are billed to me on a statutory account under Section 69, compliant with Section 69, which you may deduct from monies you hold on account if you have any. What's wrong with that agreement?
because it's not ratified, or
I mean, this case is about a situation where the solicitors have not agreed in advance with the client anything. And so, of course, you need to agree the amount and the sum to be paid.
but that's the specific sum. So it's how you look at the original agreement. So is the original agreement enough to dispose of the need to agree a specific sum that is relatable to a bill of costs as to actual work done?
Well, it's,
So,
yeah. I mean, it depends what the agreement is, doesn't it?
well, I mean,
Is there what is the warrant for an additional rule beyond that the client must agree? So, you know, obviously the client must agree, and if on a proper construction of what the client has agreed, he has later to agree the amount, fine. I mean, that's fine. But if not, not. I mean, the whole structure of the legislation is that the statutory bill is the watershed, and that gives rise to statutory rights of assessment.
in that scenario, if for example, when you've got interim statute bills, so not a final statute bill, but an interim statute bill, and you've got an agreement subject to a retainer, then every time an interim statute bill is delivered, payment can be sought. So over a period of 3 years, for example, there could be, by the time the case is ended, the client has lost either an absolute right within a month or a right under special circumstances within 12 months to have that bill assessed. If there is no, if it just goes back to the original agreement. So in a case where you've got an interim statute bill, every month that right is gone unless you can establish special circumstances.
But there must be payment. It's not just the agreement.
But if they've got, so if there's an agreement in principle, the retainer, and they've got money on account, then they could take that money every month, and that's your payment, if that's right, deliver an interim statute bill, take the money, and then nothing's said to the client. In a 3-year case, there's at least a third of that lost, even with special circumstances.
Well, you say nothing said to the client, but your submission is predicated on an interim statute bill, which does inform the client how much is going to be deducted from the funds in hand.
If it does inform them, and it does inform them with sufficient clarity, that they have a right to assess it, because they'll have to assess it at every junction of a month's period.
Where does the client's right to be told about the process for assessment come from?
So the process for assessment is what I say about the regulatory principles. But it would help if you had that.
Yes. So does that lead to the conclusion that a bill which does not inform the client of the right to an assessment is not a bill that complies with Section 69, or is there some other section?
No, it's not that it doesn't comply with Section 69, because it doesn't comply with the regulations that I refer to. That unhelpfully I've sent you at the very last minute.
Right. So you say that a bill that doesn't inform the client of the right to an assessment falls foul of some regulations.
Yes.
Legally binding regulations, not just a code of conduct, but legally binding regulations.
A code of conduct enshrined by referred to in the Solicitors Act and enshrined by the Legal Services Act.
Right. Right. So I think where we get to is that Judge Gosnell wasn't correct in Elan.
That's my position.
Yes.
Well, are you going to show us the relevant regulations?
Yes.
I've got them, yes.
I'm not sure that my lord.
Oh,
No, I haven't got them yet. But don't worry. You carry on. I'll pick it up.
well, you will get them soonest, I'm
Yes.
sure. So what do we want to look at?
Yes. So if in the email that you have, firstly, if you have a look at Section 176 of the Legal Services Act.
Yes.
And this is what I say. Section 176(1). A person who is a regulated person in relation to an approved regulator has a duty to comply
Just
with...
wait a moment whilst...
My apologies,
Apparently, they're links to websites. So, what do we do? Get the documents.
I can send the documents themselves.
Yeah. Would you do so, please?
Yes. You've got the case,
Yes.
but there's references to the Code of Conduct, the Handbook, and Section 31 of the Solicitors Act, and Section 176 of the Legal Services Act.
I mean, would it suffice for me to copy the relevant part into an email? Because the links themselves...
Yes. Yes. Well, maybe I can get my clerk to do it.
I'll wait for an email, sir.
Hmm?
I'll wait for the email, sir, and then I'll bring them in.
Okay. Thank you. Okay, well, I think you don't need to do it because my JA is doing it, and it'll be here soonest. So let's start with 176 of the Legal Services Act.
I'm grateful. Section 176(1) of the Legal Services Act, duties to regulated persons. A person who's a regulated person in relation to an approved regulator has a duty to comply with the regulatory arrangements of the approved regulator as they apply to that person. So that, I say, is the starting point.
Well, that's a duty to comply with the regulator's rules.
Yes.
Duty to whom? I mean, the problem with this kind of duty is this a duty, a statutory duty, breach of which stands in damages, or is it something that provides some other kind of right? I mean, it's complicated, isn't it?
Mm.
Anyway, let's go on. We know that there is a duty to comply with the regulatory arrangements of the approved regulator.
And then I've referred to Section 31 of the Solicitors Act.
Yes.
Because effectively that gives the power to the regulatory body to take any action if there is breach of.
So that tells you that the society, the Law Society, may make, SRA now, may make rules for regulating in respect of any matter, professional practice, conduct and discipline, and for empowering the society to take such action as may be appropriate to enable the society to ascertain whether or not the code has been complied with. So that just means that they can
That gives them the power.
they can take professional
Yes.
steps, but that's got nothing to do with duties to anybody.
No, but it's enshrined in
Yeah.
legislation that they have a duty to comply with regulations.
I think I dealt with this all in Belsner, actually, yeah. There is a duty to comply, but it's a professional duty.
Yes.
Yeah. Yeah.
And then going on from that, in terms of those duties in particular, that there should be a link to the SRA guidance.
SRA, yes.
Yes, and it's paragraphs 8.6 to 8.11.
Is this the handbook
Yes,
or the code of conduct?
sorry, the code of conduct.
Code of conduct. And you want which paragraph?
It's 8.6 to 8.11. And the applicable rule, the first rule says, you give clients information in a way that they can understand. You ensure they're in a position to make informed decisions about the services they need, how their matter will be handled, and the options available to them.
Yes. That I did refer to in Belsner. Yeah.
And then 13, so 8.13, you ensure that clients understand the regulatory protections available to them.
Yes.
Now, I have also copied the 2011 Code of Conduct because that's the Code of Conduct that was applicable at the time. Compared to the current.
Is it different?
Well, if we go to Rules 1, it talks about dealing with clients fairly.
Mm-hmm.
And 1.1, you treat your clients fairly. 1.9, clients are informed in writing at the outset of their matter, the right to complain and how complaints can be made. 1.12, clients are in a position to make informed decisions about the services they need, how their matter will be handled, and the options available to them. 1.13, clients receive the best possible information, both at the time of engagement and when appropriate as their matter progresses, about the likely overall cost of the matter.
I mean, this is developing into a slightly different case, isn't it?
It's different, but the point was raised, and it was important to tell my lords and my lady that the point, as responded to before in my submission, is wrong in that there is a regulatory framework.
Well, of course there is, and in fact this is all set out in Belsner, right? But the regulatory framework, the question is, what is the effect of the regulatory framework on the law as it is applicable to the meaning of the word payment in the Solicitors Act? And at the moment, this seems to me to go more to the HH decision, you know, where it's about what the solicitor has to do to get fully informed consent about this or that, about which there is multiple authority, which is not the issue here, because nobody has suggested that the client did not, in this case, give fully informed consent to the agreement. Yeah.
But it has been argued, although not on the regulatory basis, that there was a lack of informed consent in terms of the payment.
Well, I don't see that. Lack of informed consent to the payment. I mean, all that is said here is that the solicitor's letter was in some way inadequate because of a settlement of account requirement. And whereas the question really is whether there is such an extra requirement in addition to consent being given in the original agreement.
Yes, but that informs the. I suppose the point is the principle and the practice within this claim, and so the informed consent position is important when one considers whether there has been a settlement of account and agreement, because only with an informed position, we have said, can an amount be agreed to in order for the account to be settled and for payment to have taken place.
I mean, I think we may have to look at Belsner, because in Belsner we were dealing with this question of informed consent. My recollection is we said that it wasn't necessary.
But there
wasn't an additional requirement of informed consent.
But it's not. I suppose the use of it. It's about the information available.
Yeah.
And it all goes back to the issue of the specific sum.
But the question surely is not, has there been an agreement? Has the money been paid?
But on the basis, I would submit that there is a lack of agreement, then there is no payment. And so that's what settlement of account is, rather than a statement of account, which is the bill. Otherwise, there will be situation upon situation, like the interim statute bill, example, my lord, where there becomes an untenable position in terms of the clock starting to tick.
I mean, just to be clear, in Belsner we decided that although the solicitors were not obliged to obtain the client's informed consent to the terms of the CFA on the grounds decided by the judge, the solicitors didn't comply with the SRA Code of Conduct for Solicitors in that they neither ensured that the client received the best possible information about the likely overall cost of the case, nor did they ensure that the client was in a position to take an informed decision about the case. So we decided, as a matter of law, there was no requirement to give informed consent to the terms of the CFA. If you signed up to the agreement, you signed up to the agreement. on its proper construction, but there was a professional obligation that the solicitors had broken in that case.
Yes.
Right. Now, but that means that, if I remember rightly, we didn't mention Lord Etherton's case, but we didn't think that case gave rise to a requirement to obtain informed consent by a solicitor from his client. So it would be hard, wouldn't it, to go as far as you are here in saying you can't take monies that the client has agreed to pay in advance unless you have informed consent as to the precise amount.
But they've not agreed to pay monies. They've agreed to pay an
Fees.
amount, but they've
Fees.
not agreed to pay a specific sum.
So is that the nub of your argument?
That is the nub of the argument.
So that you say the proper construction of the, I'm just writing it down, on the proper interpretation of the CFA, the client never agreed to pay the specific amount charged, only an amount representing fees. Is that right?
But in any event,
Well, I mean, is that what you say?
yes.
Right.
So that's a question of construction of the CFA rather than the Act, is it?
Well, no, it's that the CFA doesn't allow for payment as in the Act.
What did the CF actually say? Could we just see it?
Yes.
Have we got it? It's not in the judge's
It's in the
judgment.
supplementary bundle.
Supplement.
Page 103,
Yes.
probably 104 in the electronic.
Good. Which paragraph are we looking at?
So originally at the top, we can see reference to this being a binding agreement on you, and then the next page, 104, paying us. If you win your claim, you pay our basic charges, our disbursements, and a success fee together with the premium for any insurance you take out. You're entitled to seek recovery of some of our basic charges and our disbursements from your opponent, but not the success fee or any insurance premium. You will pay the balance of our basic charges and our success fee out of your compensation. This success fee you will pay itself is subject to a maximum limit, which is detailed in the accompanying conditional fees what you need to know document, which forms part of this agreement, but in addition we agree to limit the amount that you will be liable to pay in respect of the balance of our basic charges and the success fee to a maximum of 25% of your damages as defined in the conditional fees what you need to know document. Goes on to say about...
Are the words relevant in that paragraph? You will pay the balance of our basic charges and our success fee out of your compensation.
Yes. If
So
you,
that
if
you say
that's-
is an agreement to pay fees, but not an agreement to pay a specific fee.
Yes.
So how does that work? How is that? What does it mean? I mean, if you sue, you can only sue when you've got a statutory bill. The protection in the statutory bill is you have to get an assessment.
Yes.
What is the additional step?
So the additional step is it cannot be in a document rendered 2-3 years previously, it has to be at the time of knowledge of what that sum is.
Right.
And that's...
So if the solicitors and the client had agreed that whatever happened in the litigation, you'll get £50,000,
Yes.
and in due course, 3 or 4 years later, the solicitors put the £50,000 in their bill, the client receives the bill, does nothing. Does that then become a final bill that can not be challenged under the assessment process under section 70 subsection 4?
So if the circumstance is that the solicitor has said our fees are £50,000, and that's exactly what they are, then I would say yes, that's
So
a different...
even though it's 4 years earlier?
If there is no... It might be 4 years earlier, but the amount is as the amount was.
Right. So it's simply the fact that the amount isn't precisely calculated down to the pounds and pence.
Because it's an issue, my lady, of the fairness and the information that was given to the client. And how can you agree to something in a vacuum when you don't have the information? My learned friend says, well, they agreed to the 25% and it was capped, and it wasn't that anyway, ultimately. But you cannot agree to pay a sum, payment by retention eventually being the mechanism of that payment, if we can call it that, if you don't know what you're going to pay.
So if I agree with you that I will buy oil from you every month at the market price, right, and you invoice me for the market price, does it not, and I don't know what it is, and I have no way of easily finding out, does there some requirement that I approve the market price before I'm obliged to pay it?
I would say yes.
I think commercial
Well,
men would be surprised to hear
No,
that.
but-
And women.
if you, because you say market price, and then you don't agree to a market price, and you have no knowledge of a market price.
Yeah, but the difficulty with this is that you can agree to pay. I mean, for example, you can even agree to pay a reasonable price. I mean, that could be said to be too uncertain to be a contract, but it depends on the market. In some markets, a reasonable price would not be too uncertain. I mean, the concept that you always need to approve the amount that is being charged before you can make payment is a slightly alien commercial concept.
But
Except in terms of regulation, where what you really need is a rule, possibly, as my lord might say, made by the Master of the Rolls under some provisions of the Solicitors Act, that you mustn't take your clients for a ride, which obviously would, I mean, if it were spelt out, would obviously give you the platform you need.
But if there's no appreciation of what the settlement is, and there's no interaction there, then that's the problem that we say there is. Because, again, you're looking back to an agreement from some time ago. There has never been any indication as to what's reasonable. And the reasonable question here would only come on assessment.
Yeah, but that's the whole point, isn't it? You have the agreement in principle about what's to be paid and how it, and the method by which the money is to be taken. And then you have the bill, and the bill tells you exactly what's to be paid. And if you want to take issue with it, you bring an application for an assessment.
If you know, so if you know that you can do that,
Well, if the bill refers to Section 70 of the Solicitors Act, it's not very difficult to look at Section 70 of the Solicitors Act.
in my submission for a lay client, it's absolutely alien
Well,
to be able to decipher.
if you look at the terms of business, which are also part of the overall contract, at page 128 of the supplementary bundle, under the heading Client Care, it says the firm has a complaints procedure document available on request. Your right to complain might relate to the way in which your matter is being handled or about a bill that we issue. In the case of a complaint about the bill, there might also be a right to object to the bill by applying to the court for an assessment under Part 3 of the Act. So the client's told right at the outset that there is this right.
But that then presupposes that there is no onus on the solicitor to reiterate
Well,
a right.
it doesn't presuppose anything. You say the solicitor has an obligation to reiterate that.
Yes.
Where does that obligation come from, given that the contract into which the client entered contains this information? And although Mr. Justice Bourne thought that the rubric on the bill wasn't terribly clear, this particular contract clause, I would have thought, makes it clear that there are two alternatives here. There is either a complaint or you can go to the court.
My lord, my position on that would be, because it is enshrined in the Solicitors Act, pursuant to the issue of payment and this issue of settlement of account, which I appreciate, that the binding authority that could be said to be binding authority, as in a court, isn't there, but it's persuasive in my submission that there should be an interaction at that later point. Otherwise, if we're looking at, for example, my lord, a private retainer, in every circumstance where there's a retainer entered into, if they say, well, we'll charge you our hourly rate and we'll charge you so many hours, and then the client is paying on account, but we can subject to assessment, we can retain that money, and payment is retention. In that case, you would have cases of private retainers where there is no opportunity or no requirement for the solicitor to go back to the client and say, other than here's our bill, we've already took your money, to say, is this reasonable? Do you object? Not reasonable. Do you object or accept this?
But if you do object, you can go to have an assessment even if you've paid.
You can, but in this example, there's neither rejection or acceptance.
But are you postulating a contract of retainer, a private contract of retainer, which authorises the solicitor to recoup his fees out of the funds in hand? Or are you postulating no such prior agreement?
I'm not saying that I'm saying it can happen, but in those circumstances, there should be a point, and there, in my submission, needs to be a point where there is reflection, there is a bill, which is the statement of account, and then there is agreement or rejection of that. But that's not what happened on the facts of this case in my submission. And that's why Mr. Justice Bourne went on to consider the circumstances that add the element of certainty for both the client and for the solicitor. Ultimately, the decision of Bourne, in my submission, was sound because it referred to this principle of settlement of account. And as I've said, the case law, albeit persuasive, refers to interaction on the back of an informed client.
And to be fair, you made the same point to Master Rowley, to which he recorded at paragraph 27, Miss McGungle disputed that the communications demonstrated any informed agreement on the claimant's part. And you say there had to be informed agreement, and Master Rowley didn't think so. He thought the right was in section 70.
And then on appeal, which was something that was raised in first instance as well, the issue of the settlement of account and what that constitutes.
And Mr. Justice Bourne said, well, Master Rowley didn't have the argument about settlement of account. But we've been through the cases now and we've seen what they actually say. But, I mean, I'm not sure you can take the matter much further. You say that there should be informed consent. It's not good enough simply to say, I will pay your fees, and then have them deducted only on presentation of a statutory bill. There has to be informed consent and agreement or settlement of account, whatever you want to call it, before that payment can take place. And otherwise, you get effectively an unlimited extension to section 70. And I mean, I see why you say all that. It seems very sensible if it were like that. The question only is whether it is. And we'll have to decide that by reference, I think, to the authorities and the meaning of the statute.
Yes.
I mean, it's, of course, if you're wrong, you might also say, well, the consequences are really serious because nobody knows this. And it's always been assumed that solicitors should behave properly and tell their clients all about what they're paying and why. And we'd better give greater publicity to section 70 of the Solicitors Act.
Yes, yes.
Because it would be, I mean, you say the consequences are serious for clients, particularly as I still want to call him Mr. Craig, Mr. Ralph, as Mr. Ralph explained to us this morning, in the modern age where you've got all this remote transacting and people signing up to CFAs more in hope than expectation years before they get any money, it's even worse. And you're going to tell me, which I entirely sympathise with, that there are 20-page documents that nobody's ever been known to read, and it's all very unfair.
But to take it back to that 20-page document that gives free rein.
Yeah, but you say that's just not enough agreement. I mean, I am hugely sympathetic to the submission. My only problem is that it's a question of whether it's the law. I mean, we're handicapped in this court. I mean, the trouble, if I may say so, Miss Gungle, is this, that a lot of advocates make submissions like yours, that surely they ought to have to give informed consent to this before all these consequences can follow. And the answer to the surely question is yes, of course, that would be sensible. And you're spelling out, the judge spelt out of some statements of the law in the 19th century,
Yes.
which we are going to have to go through very carefully to see whether they do add up to that particular row of beans. I mean, they may or may not. And I'm pretty open-minded about it at the moment. We'll need to go through it. But if they don't, then I think you see that you're a bit short of a legal foundation. Except common fairness.
With the backdrop of regulatory requirement.
Regulatory requirements do not lead to contractual duties. They lead to professional duties. See Belsner.
Yes, but they're enshrined, or the Legal Services Act puts a duty that the obligations are kept.
So the solicitor may be in breach of his duty to the client, for which you can complain to the SRA or possibly sue the client for breach of duty, solicitor for breach of duty. Doesn't necessarily mean you can't get your bill or that you have a longer period under Section 70.
The difficulty with having payment without clarification and it is the situation you find yourself in with an interim statute bill. Because if this is going to be a principle that applies in the round, the situation there is extremely difficult.
You made that submission that you can pay an interim bill and lose your right to assessment, and then pay another one and lose your right to assessment, and then be given a final bill for £10 and not be able to have any challenge to the 10,000 or 10 million pounds that preceded it.
Yes.
Get that?
Yes.
I mean, the risk of sounding like a gramophone record, which is an old-fashioned concept now, I understand. The Solicitors Act was written in 1843 for the way solicitors were instructed by clients in that period. 2023 is a long time after that. And actually it's not changed. The structure of the legislation is the same right back to the early 19th century.
No, it hasn't. But importantly, we have a new... If we're saying we have a new world, we have a new world where people are signing up to agreements miles away. They never have any contact with their solicitors. They enter into a 20, 30, 40-page document. And down the line, they don't know what money's being taken. They don't know what rights they have. They're told that it's industry standard, and because their money was retained, there's no mechanism then to ensure against that. So effectively a solicitor could enter into agreement, and this is not a case where we're talking about the term specifically, other than the 25% cap, but enter into an agreement and continue on for years and then a payment is taken, no action is taken by the client because they're unaware of their rights to take any action. There's no conversation had with them at the time of, I've used the term settlement of account too many times, but at that point when the bill is provided, payment's taken, they don't have an option to comment upon that, and that's the end of the story. And ultimately, yes, that would be subject to assessment, but it could be that they take, because that's not a mechanism within which they can have some sense of finality and information, then anything could happen, and that's it, because your time's run.
Can I just ask you about what actually happened in this case? Because Master Rowley placed quite a lot of, Costs Judge Rowley rather, placed quite a lot of importance on what happened around the time of settlement rather than the CFA itself.
Yes.
And we've got the documents in our supplemental bundle on page 253 and following. And what Mr. Shemwell said to Mr. Menzies, he put this offer, global offer of $275,000. His advice was that Mr. Menzies should continue with the claim.
Yes.
And then he said, if you accept the global offer, case will settle now. Our 25% deduction fee will apply. And I will work out the CRU benefits, deductions along with subrogated costs, so you're clear on what your in-hand settlement figure will be. Mr. Menzies replied, I think the same day, he said, I will accept their offer of $275,000, subject to your costs being deducted. Can those costs later be retrieved from the defendant? Is that correct? And again on the same day, Mr. Shemwell replied in effect saying, no, you can't get it back from the defendant. Is that not consent? In fact, they charged less than the 25%.
Yes, they did. But as I said at first instance, that's not agreement to a specific sum. Actually, what he's agreeing to is settling his case, not the costs arising out of that.
Well,
so if you look...
Well, hang on. I mean, the email says, the next email after the one my lord read, which is 11:21 on the 1st of March, says in the 4th paragraph, turning to the specific figures, we take 25% from the global amount awarded on all injury cases, as do other solicitors' firms. This is not recoverable back from the defendant. And then the answer, I think, is yes, just proceed, please, Paul. Many thanks.
Yeah, and he writes a handwritten authority to proceed, which is what Mr. Shemwell has wanted, and that's on the 4th of March. So has he not authorised a 25% deduction? In fact, he's been charged less.
In my submission, no, and that doesn't amount to payment because it's not at the time of the bill. So again, with no reference to the specific sum that is payable, 25% to him, I appreciate, on the face of it, is 25% of the damages. But the importance in terms of it being enshrined in going forward in my submission is that there does need to be a specific amount referred to so that the client...
He knows what it is. He knows that the damages are 275 and 25% is the cap.
But he doesn't... That can't be the point of agreement because what follows subsequently is the final statute bill. And that's the issue of payment arising out of that. So that can't be the agreement in the timeline.
So if he'd said, I agree to your taking your fees out of the damages up to a maximum of 25%, that wouldn't be good enough either?
I say no, not at that point. It has to be at the point of, it has to solidify at the point of knowledge of the exact sum referable to the bill.
Well, he gets an interim bill on the 18th of April.
He does.
And the final bill in July.
Yeah.
And you say none of that is referable. You can't refer back to the fact that in March he has agreed.
I say he can't agree in March to information that he doesn't have. Well, even in July, when he receives the final statute bill, I say he's not agreed because there is no interaction. So that final statute bill is sent out to him, and whatever I say about the amounts within there.
So even if both parties proceeded on the basis that there was a clear understanding that he'd authorised the solicitors to retain up to 25% of the final amount of damages, and the final bill is in accordance with that agreement, it's in fact less. So everybody proceeds on the basis that they've done exactly what was agreed. Nobody has any issue about it. You say that's nonetheless not payment under Section 70, subsection 4.
No, because it has to be referable to the bill. It has to be.
There has to be
the
some
bill.
action on the client's part.
And it has to be referable to the bill.
What has to be referable to the bill?
So the agreement as to the specific sum has to be referable to the bill. So it can't come beforehand because the bill is the.
It can only come after the bill.
The bill is the item for assessment. So payment has to follow.
The bill?
Yes.
Well, it did. Payment did follow the bill.
Well, we don't actually know in this case because it happened on the same day.
Okay. But you say even if it
there has
happened
to
on
be,
the same day, that's not
well,
good enough.
I mean, there has to be that interaction. So it can't come before because otherwise the interaction wouldn't occur because it has to be referable to the bill.
Okay, I think we've got the submissions. Could I ask you to just go to the case of Slade and Erlam,
Yes.
which is the case you put in your new bundle of His Honour Judge Gosnell, sitting in Leeds as a judge of the High Court. And Judge Mark Gosnell there says that the much vexed paragraph is paragraph that counsel told him there weren't any rules, right, is 26. Both counsel advised me there are no regulations. And but he then says he asks the question whether the CFA Light authorised the delivery of interim statute bills, which is no doubt led to one of your concerns about how unfair all that would be with interim bills. And he said it didn't, right, in paragraph 36 and following. But is there any part of this judgment on which you rely to support the primary case you're putting forward?
No,
You just got it out because
I wanted
because my lady
to.
mentioned it.
It was referred
Yes.
to, and I thought it was yes. There's nothing within there that I've seen that. I mean, it did lead to my concerns in respect of the issue of interim statute bill and how that would play out.
Yes, I mean, there is a reference here to Master Rowley's decision in Masters and Charlie Fussell. And he says, paragraph 28, I fully accept that Costs Judge Rowley in Masters and Charlie Fussell appears to suggest the solicitor bears this additional obligation. And the additional obligation is the judge does not go on to say the solicitor should also tell the client that if the complete self-contained bill is delivered, then this starts the clock running for the purposes of self-assessment. So it was suggested that there was an obligation anyway with interim bills to mention that it was going to start the clock running and sort of stop it effectively for everything you were charged in the interim bill.
Yes.
And he rejected that.
Yes. the problem with that was that he wasn't referred to any of the regulatory. So he refers later on in that paragraph, perhaps this would be good reason for amending the legislation or for the SRA to amend the Code of Conduct or to introduce regulations to like effect. So he's not aware of the regulations to which I now refer when he came to this decision, because counsel advised there were no applicable regulations.
He also refers to the fact that the Solicitors Act is jolly old now. Paragraph 25. The Solicitors Act is legislation of some antiquity and doesn't appear to have been amended substantially over the years. I would humbly concur and have very little useful to add on that point.
My lords, my lady, I wonder if I take a seat at this point rather than continuing to go round in circles.
What you've said has been extremely helpful, Miss Mungle. Thank you very much. And I know we've pressed you and sent you off over lunch to do additional work, so please accept our thanks for that. We really appreciate it. I think this is a very difficult case, and we've been much assisted by your submissions and, of course, by submissions on the other side.
I'm sorry to hold you up. Can I just ask one more question? It relates to what the judge said about the reasonable time.
Yes.
That the solicitor could say reasonable time.
Yes.
Looking at the letter of the 11th of July, supplemental bundle pages 11 and 12, Mr. Shemwell summarises what he's going to charge. Then he says if you wish to challenge the deduction, you've got 30 days to file your complaint. Refers to the complaints procedure. Then he says you've got the right to have your charges reviewed. And then he says, if you have any questions or queries, please feel free to contact me. Otherwise, I confirm this firm's instructions are now at an end, and we shall arrange to close our file of papers. And then he talks about archiving the file. Is that not telling Mr. Menzies that if he wants to complain, if he doesn't complain, they're going to close the file and regard everything as at an end? Well,
I think it sort of contradicts the previous paragraph, doesn't it? Because it says you've got 30 days, but I'm going to close your file in any event. I would say that's confusing at best.
Thank you.
Mr. Ralph.
Thank you. Can I just pick up, if I can, on some of the specifics of the agreement? I know my lord has taken some time to read into these, but just for purposes of addressing this issue that arose over the luncheon recess, I think we bottomed it out now, but can I just be clear as to what my position on this? I agree with the process, of course, as I would, as he set out in Bellsner, that if there is a breach of a regulatory requirement, then that lies with the disciplinary body in charge of enforcing that regulatory requirement. But in this case, what appears to be being suggested is that there is a breach, and I just want to nip that if I can. The paperwork here from the conditional fee agreement and the surrounding paperwork makes clear insofar as section 70 and what it concerns. Now, they're not in any particular order. I'll just count them through as the numbers that they are in the supplementary bundle, so the court can, when it comes back to look at this, have them to hand. You'll see that on page 95 of the supplemental bundle, there is the interim bill. And the court will see that at the end of the numbers on the second page, there is this paragraph. Now, I appreciate that Mr. Justice Bourne criticised this paragraph as allied in two concepts. You'll forgive me if I just make this observation. It's in my skeleton, but allow me if I just make it again. There was actually no argument before him about this. And the reason there was no argument before him about this was because the only evidence from the client about confusion is not that he was confused as to what that bill told him. He was confused that he was being given money back. His entire confusion is limited to the fact he got too much money back. He thought he wasn't going to get that refund. There's no other evidence from him as to any other confusion. This is something that appears to have simply been a conclusion that has been reached by Mr. Justice Bourne. And I say it's wrong.
Does it matter if the actual client wasn't confused? Don't we normally apply an objective approach to asking whether a document satisfies some sort of requirement?
Indeed you would.
We don't ask about the actual recipient usually.
And I agree wholeheartedly. And had we been asked to comment and make submissions, that would have been one of the submissions that would have been made. So then, counting back if I can, the bill itself repeats the mantra. That's at page 96 of the bundle, the supplemental bundle. And then when one turns to the conditional fee agreement, which we pick up at 103, and then, my lord, you've already, I think, taken yourself to this. At page 104, you'll see there under the paying us, the words, you will pay the balance of our basic charges and our success fee out of your compensation. Forgive me. Insofar as the client then needs to know as there were right of assessment, can I invite the court to page 119 of that supplemental
I think
bundle?
we just need to note paragraph 1.5 on page 110.
Indeed, thank you. I'm very grateful.
And that point, I think, is repeated at paragraph 17.
It is indeed, thank you. I'm grateful for that. Thank you, my lord.
Could I have that number again? 1.5.
1.5. You agree to pay into a designated account any cheque received by you or by us from your opponent and made payable to you. Out of the money, you agree to let us take the balance of the basic charges.
Indeed, and that's also page 121.
And then you want to go to 119.
And then if I could go back to 119, and the reason for that is this idea that the client hasn't been told sufficiently about their regulatory rights. 15.5 is the heading, and then the subheadings. And if I could just, it says, it is recorded that prior to signing this agreement, we explained the following. And if I could invite your eyes over the page, please, to 15.5.5, you'll see there writ large the client's right to an assessment of those costs. And again, I think we've already been taken to the terms of business at page 128, where in the penultimate paragraph on that page, halfway down that paragraph, commencing with the words, in the case of a complaint about a bill, there might also be a right to object to the bill by applying to the court for an assessment of the bill under Part 3 of the Solicitors Act of 1974. I wanted to come back on those points. I think I've already made my position clear this morning, so really I don't want to detain this court any longer than the court wishes me to. Are there any matters arising that the court would benefit from my assistance with?
What do you say about Goff?
What do I say about Goff?
Seems to me to be Miss McGungle's best case.
Right. What do I say about Goff? Well, first of all, can I make this point? I'll just get it up, but the header to Goff sets the scene for this. Forgive me while I just get it up on my machine. Goff, Chivers and Gordon is an interpretation of section 71 of the Act, not section 70.
Is it? What about page 94 in our bundle, page 9 of the transcript? I believe this court should construe section 70, subsection 4.
No, sorry, the primary question they were asking was about section 71. Then if we turn to the basic legal rules that payment case did not amount to a settled account, what is being said here is this notion that on page, I think it's 94, where the point is made. Oh, here we are. It is the timing point again. I'm picking up at page 94, halfway down the page, starting the words. In my view, E.J. correctly distinguished the revision in revision, the conclusion he arrived at was correct. Having concluded that the statement of law relied upon the judge from the speech of Bourne J was obiter, I believe that this court should construe a section 70 sub 4 of the 74 Act. The word payment, in my view, should be construed as covering the transfer of money in satisfaction of a bill with the knowledge and consent of the payer. That was the view of Stamp J enforcing our estates against Dykes and others. And then there's the quote is there. It is submitted on behalf of the defendants that the bill with which this case is concerned was paid more than 12 months ago. And that has the effect of the second proviso to section 69 sub 2 to submit and applies as well to applications for taxations under section 71(1 as it does to a taxation under section 69 sub 2. No order for taxation can be made. And then the nub of it comes to this. In my judgment, both these submissions are well founded. It is clear that if a solicitor, without the knowledge or approbation of his clients, pays his own bills out of monies of his client and hands over the proceeds, that is not payment within the meaning of section 69 of the Solicitors Act of 57. Payment is an operation in which two parties take part. I agree with that. And I make that point in my skeleton argument. If what you do as a solicitor is you pay yourself without telling anybody, then you have no right to do that. But it's a timing question. What you are going to pay and the agreement to pay does not have to be, as my learned friend says in my respectful submission, at some ex post facto point in very close proximity to the bill in a sum exact.
So you agree that payment covers transfer of money in satisfaction of the bill with knowledge and consent of the payer, but you say that the consent can be given in the contract, which entitles the payee to deduct the money.
I say no more than that. I also ought to make the point that insofar as money is concerned, I don't think the court was intending to focus that you could only pay your bill with money in that strict context. There may be other sections that would be dealing on different facts where the court will construe payment, either generally or in this context, by some form of offset of other assets. I can see no reason why in principle that couldn't potentially be possible. Section 74, section 70 sub 4 and section 69 don't speak to money, they speak to payment. So I say once you have the agreement and the transactional process which follows through the bill into payment, you have the ingredients. So
on the facts of this case, you say there was an agreement in the CFA in principle.
Yes.
Mr. Menzies was told at the time how much was going to be taken out of the fund.
Indeed.
And that satisfies the test laid down by the Lord Justice Orders.
I see, yes. And in
knowledge at the time, consent given previously.
Indeed. And there is, of course, the gloss on this case, that on the facts of this case, from the documentation that the court has been taken to, and is also self-read, it's very clear that, in fact, there was a series of steps that actually led up to that final bill. It wasn't, as I think my learned friend was trying to suggest, some bill dropped in isolation. There was telephone calls, there were emails, there were letters, there was then an interim bill, there was then a letter, there's then a statute bill. So all of those were processes. And then ex post facto after the bill, there's a closing of the file letter, which again invites this notion that if you have something that you want to raise, you can raise. So I said it has all the ingredients, but if you distill it down, I think it's the point that is made, I think it's in Reed Hugh at paragraph 3-1. Lewison and Chew. Page 314. I think there's a sort of granular.
Harrison and Chew.
Yes, in the Court of Appeal,
yeah.
My Lord. I think it's at page 314.
In the judgment of Dylan L.J.
Where is it? 1 second. Forgive me.
Yeah, these are the facts as he sets them out. 314.
It's a Roman numeral point. Where is it? I've lost it. Here we are. Sorry, it's at 315, page 315. And it's where the court addresses this factual matrix of how Mr. Tew comes to have a settled account. Of course, the court was very content that that was an example of a complete set of circumstances that led to finality. But what I say can be taken out of that, if the court is so minded, because it's about the only thing I can find where there are at least some indication of stages that required, which I think is the point you're questioning me on, my lord. It is effectively there's a negotiation which is reduced to writing, so that's sort of 1 and 2, and then there's a bill, and in Harrison and Chew that was seen, albeit I appreciate it's fact sensitive, but it's a process by which you arrive at finality, and the finality is a bona fide Section 69 bill that is delivered, and that then becomes, we say, the time from which payment starts to run.
Can I just ask where this requirement of knowledge of the bill comes from? I understand consent. Consent is obviously, it's hard to see how you make payment without consenting to the payment. Nobody really suggests otherwise. But knowledge is something slightly different as to the precise payment. Does it come from Section 69?
It does.
1.
It does.
Which says that no action should be brought less than 1 month from the date on which the bill of costs is delivered in accordance with the requirements mentioned in 2, which requires that the statute bill is delivered in a particular form, meaning come to the attention of the client.
Indeed.
And then the statute says that you can't, under Section 70, get an assessment after the expiration of 12 months from payment, and payment must can take place before delivery of the bill, but the time runs only from the delivery of the bill, i.e. knowledge of the bill.
Yes, I mean the knowledge and delivery of the bill must be synonymous. They have to be the same.
Knowledge
and delivery of the bill in this section, they must be synonymous with each other.
Yeah, but the point is, I'm just wondering where in the case of Gough and Chivers that we're looking at, which is a Court of Appeal authority, the requirement of knowledge comes from as a matter of statute, and it seems to come from a combination of 69 and 70.
It does, because the language is different. Section 69 talks about what constitutes 2 things, which is what is a bona fide bill and the fact that it needs to be delivered. So what you couldn't do, for instance, in compliance with Section 69, is have a bill that physically meets Section 69 but was not then delivered because you
and pay yourself.
Indeed, you couldn't do that.
Even if you had an agreement to do that.
Indeed, well, it wouldn't be a Section 69 bill because it's not being delivered. Yeah. And then Section 70 then kicks off with using that as its foundation by saying at 1 whether before the expiration from the delivery of a solicitor's bill. So again, that's the entry-level springboard in Section 70 sub 1, where it says where before the expiration of 1 month from the delivery of a solicitor's bill.
Yeah, well, and Section 71 was, of course, about assessment on the application of third parties, which was relevant in the Gough case because we were talking about the distinction between beneficiaries and executors.
And indeed, and I think that it can throw up issues, but the key to understanding those issues are who are the primary parties to the contract with whom the knowledge rests.
Mm.
But insofar as...
So knowledge comes from delivery, is what you say.
In short, that's what I'm saying in this context.
Right. Anything more? Anything more?
Thank you.
Yeah. Well, thank you, Mr. Ralph. Thank you, Ms. McGungle. We'll take time to consider our decision in this interesting and quite difficult case. And we'll hand down our judgments in the usual way. When we do, please provide only typographical corrections and use the judgments only to agree costs and an order. and not for any other purpose in advance of formal hand-down. And if there is a disagreement, unlikely event of a disagreement as to costs and disposition, we'll deal with those matters in writing.
Thank you.
But thank you both for stimulating day.
All right.